Welcome to Strange But True. Take a breath, slow down, and listen carefully. Some stories are documented, some are debated, some refuse to be explained. We tell you the stories, you decide what's true. Now, let's begin our journey. In most legal systems, crime begins with action. Something is taken, something is damaged, someone is harmed. The record usually opens with movement, but not always. Court archives contain crimes where no physical act is recorded. No strike, no theft, no trespass. Only classification, only intent, only position within a system. These cases are not anomalies. They appear early. They persist across eras. They reappear under different statutes. One of the earliest examples is conspiracy. An agreement is entered into evidence. The act remains hypothetical. Preparation becomes proof. Coordination becomes liability. The law records the crime as complete. Nothing has occurred. The file proceeds anyway. Judgments reference plans, meeting notes, shared language. The absence of execution is acknowledged. It is not treated as relevant. In other cases, omission is sufficient. Failure to report, failure to intervene, failure to prevent an outcome. The absence of action is reframed as responsibility. Legal codes define expectation precisely. What should have happened replaces what did. The distinction is preserved in statute. Case law expands it. Some cases rely entirely on silence, not denial, not refusal. Silence. The absence of speech is recorded. Context is supplied later. Meaning is assigned after the fact. Transcripts preserve pauses, gaps, non-responses. The physical environment remains unchanged. The charge does not. Status-based crimes appear repeatedly in historical records. Individuals charged for belonging, for affiliation, for classification. No behavior is described. The category is sufficient. In authoritarian systems, this expands further. Citizens are prosecuted for identity, for role, for inherited position. Files list names, dates, associations. Actions are absent. Economic law produces a parallel pattern. Some market manipulation cases document harm without a transaction. No trade executed, no transfer recorded, only timing, only access, only inferred advantage. The outcome is cited. The act is missing. Regulatory opinions note the absence. They proceed anyway. Military law preserves another variation. Crimes defined by failure. Failure to obey. Failure to anticipate. Failure to prevent. Expectation becomes the standard. What a role required matters more than what occurred. The body is secondary. Only the position is measured. Orders are cited. Doctrine is referenced. Movement is implied, not recorded. Speech-related cases introduce another boundary. Words become sufficient, not threats, not commands. Statements, recorded verbatim, detached from immediate consequence. Meaning is interpreted later. Intent is reconstructed. The environment remains unchanged. The verdict does not. Modern systems extend this logic further. Cybercrime cases sometimes cite no intrusion, only capability, only possession, only access credentials. Tools are equated with use. Preparation replaces execution. The record acknowledges the substitution. National security cases go further still. Crimes defined by risk, not damage, not action, probability. Future outcomes are entered into evidence, assessments, forecasts, scenarios. What might have occurred is preserved alongside what did not. Courts acknowledge the distinction. They proceed anyway. In appellate records, this tension is occasionally noted. Language narrows, definitions tighten. The standard shifts slightly, then stabilizes again. No reversal resolves that underlying issue. The framework remains intact. Only its edges are adjusted. Across jurisdictions, eras, and legal systems, the pattern remains consistent. In some records, judges acknowledge the problem indirectly. Language becomes cautious. Terms are narrowed. Standards are rephrased. The ruling remains the same. The concern is preserved without correction. The archive keeps both. Law detaches from motion. Authority shifts from behavior to classification. Compliance becomes a condition. Deviation becomes an offense. The archive preserves disagreement. Footnotes express concern. Opinions narrow language. Dissents remain unresolved. No unifying clarification appears. When action is no longer required, the location of the crime becomes unclear. The record does not explain this. It stops. History has a way of hiding the truth inside what it chooses not to explain. Inside tales, inside myths, inside legends, inside things that feel just a little off. If this story held your attention, subscribe to Strange But True, because sometimes what sounds unbelievable is exactly where the truth hides.